talk in this session, and that's by Bree Williams. And so can I just hand over to you to talk about therapeutic jurisprudence in legal education?
Hi everyone, thank you for having me at Directions in Legal Education for 2020. In my talk today on therapeutic jurisprudence in legal education, I hope to explore the ways that we can identify the therapeutic jurisprudence or TJ potential in legal education. May I begin with acknowledging the traditional owners on the land on which I am recording from, the Wurundjeri people of the Kulin Nation, and I pay my respects to elders, past, present and emerging in accordance with local law. My thesis research that I'm beginning to present to you today investigates how TJ can offer a framework for legal education that will support law academics to pivot to new ways of thinking that align with the co-creators Wexler and Winnick's objectives of intentional, aware and humane design and application of the law. The example that I'll offer is legal writing, not in an attempt to limit it to this skill area, but because clear, humanised, non-adversarial styles of legal writing are also effective, persuasive and appropriate for legal practice today. So to begin with, what is TJ? I'm using it here both as a middle range theory and a methodology that seeks to prioritise the evaluation and avoidance of the harmful impact and consequences of the law, legal process and actions of legal actors on the well-being of persons affected by the law. It adopts a flexible and yet a guiding principle that law would better serve society if we study and improve the role of law as therapeutic agent. Legal writing can be thought of as teaching the process of communicating legal thought to a reader, and so a legal's writing can be accepted as a therapeutic agent within an area of laws. A TJ framework in legal education can also enable legal academics to ground their content and approach amidst change by ensuring that a chosen pedagogical approach considers both the design and the application of laws. This would make it a more humanised approach and one that doesn't render aspects of the community invisible. So I hope to show how the methodical use of the TJ framework offers a way to enable and ground shifting demands for new content, teaching approaches and diversity of and respect for voice, validation and voluntary participation. These aspects of the law are not soft or lesser in the TJ methodology, and they're particularly relevant today. So let us see how the TJ method can, along with satisfying the legal writing learning outcomes, equip institutions and educators to find ways to enhance the voices, validation and voluntary participation of all legal actors. It does that in a way that's interdisciplinary. It's flexible. It's not seeking to be a macro theory that must be followed in a rigid way to the exclusion of other principles of justice. And it does fit within broader comprehensive law and non-adversarial movements. Yamada directs us to using the methodology from a first step of adopting the breadth and interplay of the factual and legal realities, which can include psychological, social, economic and political conditions that informing our understanding of the situation. We would look firstly to the therapeutic design of law. So we would understand law to include not just the rules and doctrine, but also the procedures, including the context and time of the law and structures that relate to the creation and administration of that law, as well as the roles, actors and behaviours within the design of a law, which can be considered to be the bottle or the container for that law, that would restrict and allow or not allow certain therapeutic applications of the law or practices that can be applied within that design of law. So that takes us to understanding how the application of the law can be evaluated or understood. Amy Ronna points us here to one method of doing this, of using the 3 V's, the voices, validation and voluntary participation of all people, all participants of the law, including legal actors and aspects of the community who are affected. Of all participants had an opportunity to be heard. Are we in our legal education ensuring that diverse perspectives about the impact of the law being included in our content and delivery? And we would take into account an interdisciplinary approach that tells us that there are understandings from areas like psychology and socio-legal schools that would inform how our application of the law could be improved and understanding any unintended psychological impact on people affected by the law. And we would need to ensure that there is voluntary participation if we are to assert that we have an effective law in an area. And this would take into account whether we are being informed about appropriate application of the law for a wide range of people in the community. And in our understanding of the law, we would be building skills to question any value-neutral objectives that are dominating an area. So I hope you can see from that methodical approach that it's depicting a more humanised approach to teaching, one that prioritises the impact of the law on people that arises from both the design of the law and the application. It's not seeking to reinforce one set of standards, excluding other ways of being and acting. And just as TJ might be an effective means of interpreting and applying standards of excellence in judging, it might also be used as a standard of excellence to interpret and prepare teaching and learning approaches from learning outcomes. This is because the learning outcomes that guide the teaching approach for a learning opportunity in a particular setting, something that's shifting often, broadly aim to develop the technical and strategic skills necessary to succeed in law, scholarship and practice. This can be enhanced by TJ informing that scholarship so that students can see and practice the skills needed to critique the perceived value-neutral nature of legal skills. That analysis and reflection and the skills for doing that can be informed by social science and psychological practices through a theoretical framework that prioritises the therapeutic impact on people in an interdisciplinary way. This departs from a teaching approach that's focused almost entirely on the rules and doctrine lying within the design of the law, to the exclusion of both the other aspects of the law and also the application of the law, which is not subjugated when using a TJ method. TJ theory informs a teaching approach that's mindful of access to justice and substantive equality issues by moving toward making the entire legal landscape essential knowledge for understanding relevant laws in an area. Legal education theorists like Grimes argue that a combination of informed teaching approaches form a truly integrated approach to teaching and learning, and one that serves those wider agendas of employability, awareness of law in social and commercial contexts, and of issues impacting on social justice. The strategies that have informed the legal writing example that we'll look at in a moment. A student-centred approach, preparation of diverse content, the use and design of learning objectives. And the three pedagogical theories that are particularly relevant to this legal education inquiry are cognitive learning theory, constructivist learning theory, and self-regulated theory. In the time, I won't go into those today, but they are important as a foundation for this approach. So each of those approaches needs to be considered in the teaching armoury and used according to the learning objectives and outcomes sought. And here lies the importance of each legal academic's expertise in an area of law. So the use or exclusion of aspects of understanding the entire legal landscape would be undertaken by the legal expert in that area. So this isn't a call to push legal academics beyond what is possible in a crowded curriculum, but it does allow for a methodical approach to consider has something been left on the shelf, or is there greater diversity and understanding of people needed. So the impetus for using the TJ framework to plan and establish any combination of the teaching approaches is that the grounded, perhaps even at short notice, but it's done in a way that learning objectives and pedagogical approaches continue to focus on both the design of law and the application of law, including law teachers and have a look here at a legal writing education approach. We would begin with learning objectives that students have skills at the completion that are appropriate, effective and persuasive. They're able to write in ways that suit their intended reader. So they would need to understand both the design of the law and any impacts that arise from the application of law, and build their skills with that broader understanding of the legal landscape. So this would involve a consideration of legal academics, taking into account language, context, time and judicial roles, any understanding of any prioritisation of value-neutral ideals when they're considering the rules and doctrine in an area. But they wouldn't exclude the broad range of other aspects of the design of law that confine or prevent therapeutic application of the law. So we would take into account, are there procedures that are access to justice barriers? Is advice being enabled in a way that is mindful of the needs of their reader? And are we understanding that our practice in an area is affected by the roles that we learn that could be laden with adversarialism, the prioritisation of a law and order rhetoric? Are we ensuring that early intervention and interdisciplinary advice in relation to that is understood in a particular area? Again, an assessment made by the legal academic. The skills would then always be adapted to ensure that the 3 V's, that any practices and skills learnt can be adapted so that they are appropriate and effective, taking into account voice, validation and voluntary participation that would vary according to the individual needs of people affected by the law. That's something that's very essential. So that's a brief introduction to a teaching approach planning process. Obviously, it's not to the end delivery point, but it would take us to a position where we are producing lawyers who are aware and understanding of the people involved in both the design and application of the law. So legal writing education in that way can be thought of teaching the process of communicating legal thought to a reader, as I said at the outset. So if it's intimately linked to learning to think and analyse in the legal context, then it's a fitting learning opportunity for therapeutic jurisprudence to inform the teaching method for legal writing. This is because it requires the highest cognitive legal learning objectives. And in order to craft legal writing in a way that avoids anti-therapeutic impacts on clients and colleagues, students must have the skills to distill, redefine, create and prioritise all of their information to suit each reader. And if law academics do not have a pedagogical framework that allows them to shift and diversify their learning opportunities, then something might be left on the shelf. We might be rendering some clients invisible, and when graduates seek to problem solve outside of law school, they might have learnt to do that in a way that we replicate client and fellow practitioners' invisibility. This anti-therapeutic educational outcome may be dehumanising the practice of law, or at least restrict the way that students envisage the law for the remainder of their careers. So I have gone a little over time. I thank you very much for joining me in my home among the gum trees, and I'm looking forward to your questions. Thank you.
Thank you very much indeed, Bree. So as before, if there are any questions, please put them in the box. But and I've got some, but I just wonder whether either of our two previous speakers, in fact, I can see, so Professor Neuwirth, actually, it's in the box there, but would you like to, do you want to I can read your question, or you could just...
I can ask it too, if I may, yes. And no, I wanted to, I'm sorry for the selfish question, but I was wondering from previous conversations I had with people involved, especially in dispute resolution, whether an oxymoron by putting two opposite positions into one word can be used to help ease the tensions and solve conflicts. So could they be considered as kind of non-adversarial writing, as you mentioned? So can they have a positive therapeutic effect or not? Sorry, thank you.
I don't know the firm answer to that. What I would say is that TJ would say that we need to seek that answer from an expert outside of law. So that would probably be the extent of my knowledge in using that in dispute resolution. Yeah.
But am I right in thinking the reason for mentioning that is, so you talked in your talk, Bree, you talked about kind of hearing different voices, and so I suppose that's the tie-in with dispute resolution.
Yep, absolutely. So. In relation to dispute resolution, the need would be to understand the positions that people might come into those processes are deeply affected by their position in a socio-economic sense, but also how their dispute has been communicated to them and their access to justice and access to advice in leading up to that, to participating in the process, and that the process itself has an impact, and the way it's explained to the participants has an impact on their ability to participate, and also their feeling of whether the process itself has validated their position in terms of the dispute, but also their ability to carry on with any enforcement or rejection of an outcome. I'm not sure if that answers your question.
Can I just ask one of the questions that in the box from Esther? Things again. There's a lot of emphasis on how law and application could have an impact on people. But what practical knowledge and tools are available to reach that understanding? I think that goes perhaps back our oxymora, practical tools. So how practically what knowledge and tools could be used to help? I've made a mess. I'll read the question again. There's a lot of emphasis on how law and application could have an impact on people, but what practical knowledge and tools are available to reach that understanding for teachers, students, and lawyers?
Well, it would depend on the area of law, but any sort of experiential learning that has authentic access to the real people who are affected, but who are also implementing and practicing the law in an area would be the most practical tool. But also understanding different viewpoints and understanding different methods of communicating the law to diverse sections of the community, and understanding different views and experiences within an area of law would all be practical ways of understanding and experiencing it. But even just diversity in readings in a very simple way is a way of making sure that students read and have some experience of seeing the law from a variety of perspectives.
So just look in case anybody.
Yeah, if I may just add, when you say different viewpoints, that's what I meant by referring to paradoxes, or because they put the most extreme two forms of viewpoints into one, like cold and hot, or right and wrong. So is that my experience? I do use it a lot in classrooms, especially paradoxical images. You know, those images where you can see, depending on the angle, you see a horse or a frog or an old woman or a young woman, which is used to establish sometimes whether you're more left or right brain centered, and so on and so forth. I think this, in my view, helps a lot to enhance the spectrum. And I think every conflict between two parties in particular needs to be lifted to a higher level in some way, or transcended. And that, I think, helps, but I have never thought of putting it in context with therapeutic jurisprudence. But thank you very much.
So you've got to say there's never been a time in recent history when we've had greater need of therapeutic jurisprudence and therapeutic writing than anything that promotes really understanding each other than the times we're living through right now.
Yeah, definitely. I think it also allows us to identify when we have these shifting pieces and pressures to shift, for example, all of our teaching online, that we have an opportunity to use a framework to show that certain approaches might be leaving aspects of the law out of our learning opportunity, and that we need to find ways to increase resources or increase time to make sure that the entire legal landscape is being covered.
Great. Bree, well, that's fantastic. Thank you. And it's been overall a very good discussion and a pleasure to hear all three presentations.